My name is Andy Seelig. I'm the Executive Director of the Minnesota Voters Alliance. I appreciate everybody taking time out of their busy schedule to join us today on this beautiful day. We're here today to announce the filing of a lawsuit in Ramsey County District Court against Secretary of State Steve Simon. What is that lawsuit about? Well, our particular concern is there's a lot of close elections in Minnesota. Not only did we have a recent U.S. Senate election decided by 300 votes, there are many House and state elections decided by 100 votes or less, including some city council races decided by 1 or 2 votes. There's been a couple of instances of mayoral races that actually ended up in a tie, and the candidates had to flip a coin. We're here today to talk about what our lawsuit involves and what it doesn't. What our main focus is, and our problem with Minnesota's election system, is twofold. Number one, we think Minnesota is one of the worst election systems in the country. Namely, with election day registration in presidential election years, over 500,000 persons register and vote in Minnesota elections. Keep in mind, those registration forms are not even entered into the statewide voter registration system for 42 days. And they are not checked for months afterwards to determine their eligibility. The elections are certified within a day or two. So I hope everybody can understand and appreciate that we have an upside down problem that's been going on since 1974. So what our problem consists of, basically, our lawsuit against Secretary of State, is for his policy in the election judge guide that allows persons to vote who are known to be ineligible to vote, simply on their own sworn statement. Who are those persons that we are talking about in our complaint? We are talking about persons who the court has taken away their voting rights, either because they are a convicted felon, which the Constitution prohibits, or they have been determined to be mentally incapacitated to vote by a court. Our data that we have submitted to the court is over 7,000 pages. There's almost 2,000 cases that we've identified as persons who were under court order, who were simply given a ballot based on their own self-certification. One of the problems we have with self-certification is, do we really want to allow persons who have felons who have committed murders, robberies, rapes, child molestations? Do we really want a system that simply lets them just vote and on their own sworn statement? Furthermore, when you look at court orders, let's talk for a second about incompetent persons. We know, in Brainerd was a big example, where a whole group home of persons who were mentally retarded severely. In fact, one of the mothers was one of our plaintiffs in our federal case. And these persons are taken down to vote. They have no idea what a ballot is, what the oath is. They have absolutely no idea who's running. One guy was asked, he was able to spit out the words Ford. Gerald Ford, he thought was running in the last election. When you look at the forms that they signed, this is Craig Ruskins from Brainerd. He didn't even know where to write. He can't even write his name. I encourage any of you from the press to look at this form. These are the kind of people that are being exploited in large numbers, we believe, by political predators who are taking advantage of these people at the voting booth. But I just wanted to touch on a couple things, that this policy that we're talking about by the Secretary of State in the election judge guide, that simply tells the election judges, just ask them if they're under court order. Does anybody think this person knew if they were under a court order that they were mentally incapacitated? Why does the Secretary of State have a policy that just asks them if they're under court order, when in one hand, they already know? That's what our lawsuit comes down to, folks. The Secretary of State already knows the majority of persons that are ineligible, specifically those that have a court order restricting those rights. And the way I look at it is, it's no different than absentee ballots. All of you have probably cast an absentee ballot before, right? What happens when you vote absentee? If Jane Doe votes absentee, if she walks into the voting booth on election day and tries to vote again, the election judge is going to find Jane Doe's name on the roster, and you know what it's going to say next to her name? Does anybody know? AB, absentee ballot. Sorry, Miss Doe, You already voted today, no ballot for you today, okay? What we're arguing in our case is no different. The person who came in and tried to vote again is just as ineligible to vote as a person who the Minnesota judicial system has removed that right to vote. So that's our major concern. The state can stop it. It's an easy system to fix. And we thank you all for coming. And I'm going to pass it on to Cindy Pugh, who is a vice chair of the Government Operations and Elections Committee. And she's also, I believe, an election judge. Cindy?
Thank you, Andy. Good morning. I am State Representative Cindy Pugh from Chanhassen, and I do serve as the Vice Chair of the Government Operations and Elections Committee. Election integrity has always been of the utmost importance to me. In fact, I happened across a sign that I made years ago. I believe it was that I made it during one of the recounts in Minnesota, well before I ever considered running for the Minnesota legislature, and the sign rings just as true today as it did the day I made it. Election integrity does matter. It matters a lot. And if re-elected, I will press forward to make changes in the law that improve election integrity and transparency in Minnesota. This should not be a partisan issue in any way, shape, or form. Having served as an election judge in the past, I believe I'm speaking for this group of conscientious citizens who give of themselves when I state that no election judge would want to be put in a position to hand a ballot to somebody who was in fact deemed by the courts to be ineligible to vote. I'm hopeful that Secretary of State Simon and the county election officials will receive this petition with an attitude of, let's fix this and make the system both consistent with the law and common sense goals that support election integrity. Minnesota, as we all know, has often been referred to as the state that has one, if not the most exemplary election systems. However, the research and analysis, the comprehensive research and analysis that has gone into this petition clearly indicate that we have work to do. So I'm encouraging strong support to let's just fix this and ensure that we really earn our reputation going forward. So thank you so much.
Thank you, Andy and Cindy. My name is Eric Cardall, and just a little background on me. I went to Redmond Falls, Harvard College, University of Chicago Law School. Been practicing for 25 years, and for the last 20 or so, have focused just on representing businesses, property owners, and citizens suing the government. In this process, I've developed what I call strategic litigation against the government, which may mean multiple lawsuits in a single subject area. As a result of this, I've beaten the government in 25 different subject areas, including townships, cities, counties, state agencies, state officials, federal agencies, and federal officials. So we know what we're doing. The Minnesota Voters Alliance has been involved with the strategic litigation against government strategy here. This is our third lawsuit, and one of the problems with suing the Secretary of State on election law violations in Minnesota has been, where do you bring the lawsuit? When the Secretary of State violates the idea of each vote having a full value and allows ineligible voters consistently to vote, diluting the votes of eligible voters, where do you bring the lawsuit? The Minnesota Voters Alliance initially brought the lawsuit in federal court, and that case was dismissed after years of litigation for not being the right court. Then, this June, we filed in the Minnesota Supreme Court under the statute 204B. 204B says that the Minnesota Supreme Court has original jurisdiction over errors and omissions of the Secretary of State. The decision of the Minnesota Supreme Court on September 28th, last Wednesday, is historic. It's historic because procedurally the Minnesota Supreme Court has made clear that our problems with the Secretary of State's office can now be brought in lawsuits in the district court. I'm going to be practicing another 20 years. Minnesota Voters Alliance is going to be around, and we are going to take the Secretary of State's office and we're going to clean up the election law system. Now, it may seem very strange that the people have to, through lawsuits, manage the Secretary of State to get a better election law system. But there's been so little court review over the last several decades of the Secretary of State that we have all these errors upon errors. Now, some of them might be intentional errors, some are unintentional, but the one we're talking about today is so awful that the people of Minnesota have not been able to correct it. It's so awful because it's so obvious. Why haven't the people of Minnesota been able to get the Secretary of State to correct this error? The error is that since the Coleman-Franken statutory reforms, the judicial branch informs on a regular basis the Secretary of State's office over there of who's an ineligible felon. These lists are provided to the Secretary of State's office. Those lists then are used against the state voter registration system, and then they create the precinct rosters, and then the lists are thrown away, and we'll get back to that in a second. With respect to the state voter registration system, when the precinct rosters are created, rather than saying felony ineligible, which is exactly the information that's given from the court to the Secretary of State, they put felony challenged. And challenge is a word that has technical meaning to the election judges. That means that the ineligible felon can raise their hand, testify that they're eligible, then they're given a ballot. True, later they can be prosecuted for voting while ineligible, but the ballot counts because we don't have provisional ballots. This is a disaster. This means that my vote can be canceled out in a close election. I'm an eligible voter, and an eligible voter cancels out my vote. Why would any state as populous as Minnesota, as concerned about democracy, even at the expense of the republic, allow any ineligible voters to vote? It was so convincing to the framers of our Minnesota Constitution. There's actually a provision in Article 10, Section 1 saying that ineligible persons shall not be permitted to vote. You know, why does someone put such a common sense thing in their Minnesota Constitution? Because they mean it. Ineligible people should not be allowed to vote. Isn't that, after all, one of the purposes of the election judge is to stop the ineligible person from voting. And that's been the way since the beginning, except for these recent times when we have decades of Secretary of States of both parties who've allowed this to occur. The second problem is, and I got to get back to this, the Secretary of State then throws away the list from the Supreme Court administrator. Why is it important that they throw away the list? Because as many of you know, in presidential elections, 20, 30, 40% of voters can be election day registration. So the only list provided to the election judges by the Secretary of State is the registered voters who are felony ineligible, marked felony challenged. But then there's another set of voters, ineligible voters, who show up, these felons, and they just register. And because the Secretary of State has thrown away the list, there's no check at all. Now, this was raised in the Minnesota Supreme Court briefing, and the Secretary of State suggested two things. One was, well, that would be a lot of work, but then we took the number of precincts divided by the number of ineligible felons, and the list for each precinct, now the system wouldn't be perfect, but at least we get most of the people, would be about 50 people per precinct. So it'd be a one-page list, 50 people per precinct, ineligible felons would have to be checked for the EDRs. This is what Minnesota wants. Minnesota wants practical, common sense reforms to its election law system. I've been litigating this issue, I think it's for the Minnesota Voters Alliance for 5 or 6 years, and this is what it takes to get these kind of practical reforms. And I appreciate Representative Pugh mentioning we need legal reforms. Well, we do, but not here. We have the law. The law is adequate. The law says exactly what I'm saying, and that's why the Minnesota Supreme Court last week on Wednesday, they read our petition, they reviewed it for 3 months. They said, you know, these are basically good faith claims, and we're going to send you to the district court, and they did it in time so that we can get this accomplished before the November 8th election. Now, why do I know we can get this accomplished before the November 8th election? Because we have an expert, the former Secretary of State, who indicated that if the Secretary of State were to inform the election judges, not felony challenged, but felony ineligible, guess what? It would save time at the polling place. Because when a felon comes in who's ineligible, the election judge would say, I'm sorry, you can't vote. And that takes less time than the ineligible felon taking the oath, writing down the application, and being allowed to vote, and then, according to the Secretary of State, prosecuted later. Why do we want these unnecessary prosecutions? Maybe the person isn't sort of educated with respect to their status to vote, but certainly the Supreme Court is. And that was the second thing that the Secretary of State brought up in their brief, and that is that somehow the Supreme Court was providing inaccurate information to the Secretary of State. And we don't agree. We think the Supreme Court does a fantastic job with respect to these lists and communicating them to the Secretary of State. So we think the Secretary of State is in error, that the court administration is in error in providing a list of felony ineligibles. As a practical matter, the petition to the Supreme Court, which is identical to the one we'll file in Ramsey County District Court, is on the Minnesota Voters Alliance website. We're just changing the captions, and we're trying to communicate with the Ramsey County District Clerk. We just did before the press conference today about exactly how they want to receive the information. One of the challenges in this case is the Secretary of State denies that there's a problem. And so that what we did, and this Minnesota Voters Alliance volunteers, paid workers, because it was so much work, is the Secretary of State wouldn't tell us how many ineligible felons were voted. The Secretary of State knows, but the Secretary of State doesn't want to share that information with you because that's kind of a government secret. Right now, in a populous state like Minnesota, there aren't supposed to be government secrets. But the Secretary of State keeps the government secret because he doesn't want the people to know how many ineligible felons are voting. But here, there is enough information on the internet and elsewhere that the Minnesota Voters Alliance was able to figure out that about 2,000 ineligible felons voted in the last, I think, 3 election cycles. And the way they did that was you can find out who voted from information from the Secretary of State, and you can find out who the felons are who are ineligible by going to the court website and searching the criminal records online. And by connecting the names and the addresses and the birth dates, you can almost for certain, 99.99% for certain know it was an ineligible felon. And then if you're not convinced by that, hundreds of these ineligible felons were prosecuted and convicted for voting while ineligible. So that should convince you, right? If the government's gone all the way to charge, convict, and sentence an ineligible felon for voting, then they must have been ineligible that are voting. Now, what the Secretary of State would say would be, well, we didn't know that they were ineligible on the day of the voting. But if the state court administrator, that we know, is delivering the list to the Secretary of State, then the Secretary of State knows they're ineligible on election day when they register to vote, unless he throws away the list. But we've been litigating this issue for, like I said, 5 or 6 years. The Secretary of State shouldn't be throwing away the list, because the Secretary of State knows that they're ineligible, and now we know. So with respect to the Secretary of State's arguments regarding what we're about and what we're doing, none of their arguments hold water. For example, the government will say, you're trying to intimidate voters. You don't intimidate ineligible voters from voting. You just tell them they can't vote. That's not intimidation. People who are eligible to vote should not be intimidated when people who are ineligible to vote are told they can't vote. Minnesotans are populous, they're strong people, very strong. And when they're eligible to vote, they will go to the polling place and they will intend to vote. And if someone over there is told, you're ineligible to vote because you're an eligible felon, it will not deter any Minnesotan from voting. It can't, because we're a strong people. And we're not going to be intimidated by election judges doing their job. In fact, that's what we expect, is election judges to do their job. And that's not what's happening. So we expect to win. We expect this lawsuit, particularly, we're having a great amount of sunshine in the district court, and sunshine is the greatest disinfectant. It's a disinfectant for the Secretary of State and these election judges who have been hiding in the shadows with respect to this issue for now 5 or 6 years. And it's also a way to hold the whole system accountable. And again, our position isn't we're against government. When the state court holds a government agency or government official accountable, it redeems the system. In the end, our mission is redemptive. It's to help, not to hurt. And just because there's some casualties, people have to admit that they're wrong. That's part of politics, part of government. And so here the sad part is that all this has been kept secret from the people. It's all now being exposed, and the Secretary of State owes the media some answers, particularly with respect to to this question. Why do you allow ineligible felons to vote for this long? Why in every cycle? I mean, the ineligible felons in the Coleman-Franken race exceeded the margin of victory. Many contests in Minnesota are decided by 1 or 2 votes or a tie. We don't want those decided by ineligible felons. In this election, too, we have a state constitutional amendment, and every ballot that's passed out counts as a vote. Even if you don't vote on the constitutional amendment, that counts because it's a no vote. So this is messing up the whole system, and there's nothing more important in populous Minnesota than election laws and election laws being administered fairly. Thank you.
Take a couple of questions.
In your initial statement, you made several contentions about people who are psychologically incapacitated. It sounded as though you were making some sort of a judgment that there's a blanket provision that prevents those folks from voting. I have a son in a group home who I encourage to vote to protect his own interests.
Yeah, no, and that's a good question. I think is that the question?
Well, I'm wondering if you think there is a blanket provision. I've not heard that.
Okay.
Yeah,
And also, you didn't continue with that line of.
Well, let me take 1 second to just explain myself.
Yeah.
As a result of our work, that mentally incapacitated persons have been exploited. Okay, and our main, we were actually called by people up in Brainerd. That's where it started, in a group home called Clark Lake Homes. Many of them had court orders. See, prior to 2003, the Minnesota Constitution says if you're under guardianship, you can't vote, period. Okay, period. In 2003, and we support this, the statute, the legislature wisely said that if you're under guardianship, you can vote, unless you had a court order deeming you mentally incapacitated to vote. Okay? What we argued is that doesn't go far enough, because the Constitution still says if you're not, it says under guardianship or not mentally competent. So we argued that in order to comply, for the laws to comply with Article 7, Section 1 of the Minnesota Constitution, they have to be assessed. So as a result, there was a gentleman by the name of Erickson who had a court case in Hennepin County, Judge Quam, who we cite, who actually agreed with us and against the federal court judge. Judge Quam ordered, and I could email you the actual opinion. It's a phenomenal opinion. What Judge Quam said is, in order to, you're right, that person can vote as long as they're competent to vote. And I trust that every benefit of the doubt is going to be given in any guardianship proceeding to persons that you described, such as your son. Okay, but now as a result of Judge J. Quam's decision in October of 2012, every guardianship proceeding in Hennepin County, every one on a daily basis, as we're talking right here in this room, there are guardianship proceedings going on, and one of the things that they have to do now in Hennepin County is to assess that person's ability to understand the nature and effect of voting.
Thank you.
Right, so I have a handicapped sister, so I'm in the same boat. She can't vote because she doesn't have the capacity. But on that, then our decision at the Minnesota Voters Alliance has been to take on a long-term litigation strategy that, with respect to people under guardianship, that they be individually assessed by a judge and whether they're able to vote. And so that's part of earlier and future litigation. Here, this lawsuit is focused in part on once people are assessed to not have the capacity to vote, does the Secretary of State properly reflecting that on the precinct rosters, because they are ineligible to vote because the judge has given them a test. You understand the choices here with respect to voting and so forth, and the person has failed the test. So that would be sort of guardianship ineligible, and we're concerned that those indicators also are not getting on the precinct rosters. But again, we've had limited access to the Secretary of State. We've made several Minnesota Government Data Practice Act requests in this and other areas, and he just won't cooperate, even though the Department of Administration Information Policy Analysis Division has suggested in advisory opinions that he must cooperate. So it's an example of where we've done our work, we've gotten to places where others haven't gone to try to get information, and the Secretary of State wants to keep it as a secret. So that's, now we've gotten some flack in the earlier litigation from groups representing disabled people, and they misstated our position. Our position is that the best thing you can do for an incapacitated person is have an individual test with respect to voting, and that way each person is treated with dignity, and we have those people who should be voting, like your relative, voting, but people who shouldn't be voting don't get a ballot for someone else to fill out. And that was the Clark Holmes situation. So there's two sides to the coin, but it's very important to understand that there's a question of who's eligible and who's ineligible, and then this lawsuit's about why does the Secretary of State allow all these ineligible people to vote as a matter of methodology? And we're on the Secretary of State. I mean, I'm on him. Whoever's in the Secretary of State's office, we're going to be on these election law issues for as long as we're here, because it's so important to populous Minnesota. Why does such a talented group of people get together and want to have a better election law system in Minnesota? It's because we love Minnesota. We love the way it is. And then you ask, why is it that the government is so obstructive and lack transparency? Why would the government keep secrets from the people? And we're not going to stand for it anymore. And we know the district court, the Minnesota Supreme Court, in last Wednesday's opinion, called it a great court. And the district courts in Minnesota are a great court. And one of the great powers of that great court is it can order the Secretary of State what to do. And we expect that to happen before the election.
You said that the Supreme Court reviewed your petition for 3 months. What gives you the idea the district court's going to come up with some remedy by election?
Well, we think that it's required under the court rules for it to consider our petition before the election. And we think the remedy is so simple that on the precinct rosters, the Secretary of State would have to inform the election judges if it says felony challenged, it means felony ineligible and don't give them a vote. And there is a history, if some of you recall, of the Secretary of State, and Secretary of State Mary Kiffmeyer attested to this, making changes like this up until and on the day of the election. One example would be, that I was involved in, was with polling place apparel. The Secretary of State's office, a day or two before the election, said, you can't wear politically themed t-shirts. Everyone knew you couldn't wear t-shirts that said, vote for your candidate. But the Secretary of State, just a day or two before the election, said, we're going to issue a policy that even politically themed t-shirts and apparel and buttons aren't allowed. And so in that case, it was about whether Tea Party members could wear t-shirts saying liberty and economic freedom and so forth. And that issue is up on appeal. Minnesota Voters Alliance is involved. And it actually has been selected for oral argument on October 20th at the University of Minnesota Law School. It's an 8th Circuit argument, and it was selected to be heard there in a special setting. But the point is, the Secretary of State has in the past had a custom of making changes up to the day of the election. So we'll use those as examples for the district court judge, where here the injunction would require the Secretary of State to do something that would save time for the election judges. It wouldn't create any more time demands because they just read felony ineligible rather than felony challenge, and you don't have to go through the affidavit process.
Yes, that's right. And by the way, too, Wisconsin and Iowa both check for felons. I mean, in Wisconsin, I talked to the Secretary of State's office there about a month and a half ago. They actually they let felons vote, and what they do is they write in big red marker, challenged felony. So if there's a close election, then they can take a look at how many there were, and then take a course of action after that. So, and by the way, I just want to touch on the group home situation. By the way, we were actually called by the parents of some of these people who, and one of them made national news. That guy was furious. He fought for a year that his son was exploited for voter fraud. Every day for a year, and a year to the day, his son was taken down to vote. He dropped dead of a heart attack. But the other disturbing thing about what happened in that particular group home, 23 or 24 residents all were given campaign shirts and hats of the candidate and treated like dogs. And I mean, how furious would you be if that happened to your son? I mean, that's a pretty bad thing to do. And you wouldn't think people would be like that. You wouldn't think in a great nice state like Minnesota, that people would exploit people for their vote. But I can assure you that there's people out there right now going to group homes and senior homes, and they're not concerned with if they have a court order or if they're not, or in areas where there's a lot of felon voting. I happen to know a lot of felons, and most of them think, well, number one, you should have to wait till you complete your whole sentence before you're restored to vote, like Minnesota, which has the correct policy. But you shouldn't be allowed to vote prior to your rights being restored. You should have to prove that you are able to live by the laws that we all have to live by.
Do you expect this to take effect for the upcoming election?
I think that's what Eric just talked about. We're counting on him.
This is such a common sense thing. That, yeah, I mean, I understand that in populous Minnesota, we have our own sort of sense of patience with the government. We let the government occasionally override our rights and do imperfect things, and we get around to it. But here now, this is our third lawsuit on the subject area, and the Secretary of State is out of answers. Why, when you have the court informing you felony ineligible, you allow them to go through the challenge process?
But do you have reason to believe that the Ramsey County Court, is that first being filed?
That's right.
Do you have reason to believe that they're going to act in time for the election? There are only a few days left.
The election is that important, yes. The Ramsey Court, I expect the Ramsey County District Court to act prior to the election on the simple point that if the courts inform the Secretary of State that someone was felony ineligible, that they not be allowed to vote.
Where does this list exist?
It's communicated pursuant to statute. It's sent by the judicial branch to the Secretary of State.
Is that list maintained?
It's regularly updated by the court administrator's office, and we've been given copies of those lists.
Right, we have, and I think you touched on that. It's not really maintained. The law requires the Secretary of State to get that list from the court administrator and then check the SVRS, the statewide voter registration system, to see if that person's in there. If that person's not in there, he throws it away, like Tom Brady threw away the cell phone. Right. Why would you throw the list away, Mr. Secretary? Don't you think it would be a good list to keep on hand?
Right, so that's the second aspect. The first aspect is the person that he does update, he only puts felony challenge, and they're still allowed to vote if they self-certify by a sworn oath that they're eligible to vote. The second aspect of the problem is when the list is thrown away, then with respect to election day registrants, there's no check, they just vote.
How many felons were charged in the last election?
Well, there was 100. There was our data from the
Were
court.
charged by.
What do you mean by charge? 107,000 felons.
Charged with a crime because they voted.
There was 200 and some, but the only reason those were even convicted was because a private group, Minnesota Majority, found it all and did all the work. So when the Secretary of State tells you we have a good election system and we go after them and put them in jail, they don't go after anybody. It doesn't happen. That is a lie. Okay, it was private groups that found out that people were ineligible. And then out of the 250, the majority of them got convicted of knowingly, illegally voting, and the other ones got convicted for knowingly registering. Okay, so there's a difference between registering and voting.
All right, so basically the Secretary of State has the answer to that. All they'd have to do is run their data against the data they have, but they're unwilling to do it. And so what we've done is we scrounge up the information we can. Plus, Andy's right, with respect to the charges and convictions we're getting, the Secretary of State does nothing unless pushed by these groups that are doing the complaining. And every time they've done this, they've had hundreds of prosecutions and convictions. Most notably, it was 700 in the Coleman-Franken year, and that exceeded the 312 margin voting victory. So Minnesota, is close in a lot of these elections, so it might turn on the number of ineligible felons voting. But the Secretary of State will have the answer to that question.
So you suggest that you're going to be doing this for the rest of your career? You'll be continuing these lawsuits?
Oh, way past that.
Well, presumably the object isn't litigation in perpetuity. Presumably you have an object. What is your ultimate object? Is it to get a voter ID law passed that sustains through court?
No, we're not talking about voter ID now.
What do you want to achieve?
No, I'm sorry. So the ultimate object, for me, I'm a lawyer who's involved in litigation with government, is to see if the Minnesota people can use their democratic inputs, go to committee hearings, lobby for election, whatever, and litigation, which I'm involved in, to get the government to comply with the law. In a populous Minnesota, the law would be sacred. And that would mean once the law is passed, the agencies, the officials, and the courts would adhere to the law. What I found in my experience is that's not the case. The people are not managing the government through the law, and because we don't have that, the agencies just do what they want. And it's all over the place, and the people, these companies, these businesses, they're cutting corners so they get the big contracts, get the money. And so my proposal is that my practice is to bring lawsuits against government agencies when they violate the law, and that when we win, that redeems the system, and when we lose, we learn something about the system. And so in both cases, we're learning. Sometimes the courts don't require the government to follow the law.
So your object is to learn?
Learn about how democracy works, because when a democracy would work, that the people would manage the government, and apparently the other side believes the government should manage the people. This is the ultimate battle, and the only way our side, the people, can manage the government is if we enact laws and have the government follow them. Whereas the elites in Minnesota, they think the government manages the people.
That gets to my point. What laws are you talking about? You want
Here,
to
the law, the Minnesota Constitution says that only eligible people should be permitted to vote, ineligible people should be excluded. A law here is with respect to the court orders saying the consequence of the court orders, felons are ineligible to vote. And so if the court says that it's a separation of powers issue, how can an election official allow that person to vote? It's almost like when they self-certify on the affidavit that they're amending a court order. And that's not the procedure Minnesota has voted for. Minnesota has voted ineligible people can't vote pursuant to these felon court orders. And here, the Secretary of State and the election judges are allowing that person to sign an affidavit essentially amending the court order or nullifying the consequences. We believe, this is personal, we believe that every agency should follow every law because they're enacted and they're sacred. And the people use laws to manage the government. And what we found is that in Minnesota, there are these elites and experts, and people who want to make a buck off the government. They want power, prestige, that they don't care about the law. So yes, in the end, as you can see here, it is a cultural and political battle as well as a legal battle. But you have to attack the culture of these people being serial violators of the law. For example, Secretary of State Ritchie, prior to Simon, we worked so hard in our litigation that even the media agreed with us that in some instances and used the phrase that Ritchie was a serial violator of the law. And so we have so many of these in government where they're not going to be held accountable, they'll violate the law. Now we, the little people, have to follow all the laws, even the little laws. But we're shocked by the big people in the government, they can violate all the laws, including the big laws. Thank you so much.
On the court of first impression, what was the Supreme Court's argument? Obviously, the statute said, hey, Supreme Court, this is yours, you should deal with this. There's kind of an emergency situation. So what were they trying to wiggle out of here to not hear the case?
No, I can't do that to the Supreme Court. This was a historic procedural decision. And so I think what happened was that they were presented with a good faith claim, and they had to make a choice. Is this going to be the court of first instance for election law challenges to the Secretary of State? And the Supreme Court, per curiam, meaning that all the justices on the court, I think one abstained themselves, so 6 of the justices, wrote together a published decision saying these cases will in the first instance go to the district court. And so for Minnesota Voters Alliance, for myself, for all the people of Minnesota, the district courtroom door is blown open on election law violations, and the Secretary of State and election law is really important. And if you want to hear the grievances, you've heard the grievances from Minnesota Voters Alliance. There's a laundry list of issues where our system can be improved through court action because the laws are already good enough. Representative Pugh said we might need more laws, but the problem right now is the laws that we have aren't being implemented as they legally should be. And so I agree with the Supreme Court decision. I wish we had gotten it a few months earlier, but that's water under the bridge. But the point is, it's a great decision for Minnesota Voters Alliance. It's a great decision for the people of Minnesota.
Yeah, one of the other legal challenges that you'll be seeing is going after the data. We believe all the election data is public data, and we've made repeated requests. We've spent several $1,000s asking for all the election data that's clearly public as per 201-071 or 201-091, and they fought us tooth and nail. Our last request, they wanted $30-some thousand from us just to give us the aggregate numbers of the persons who were marked challenged or anything other than active, which is really what we want. The statute said that the public, which the media should be very interested in, the public is entitled to all registered voters. So we say, if you're in the SVRS, regardless of your voter status, that you are registered and that data should be public. We went to IPAD, the Information Policy Analysis Division. I don't know if you ever heard of it. It's an administrative remedy. It's a government group. We went and appealed to IPAD, and the attorneys at IPAD came and agreed with us that that data we're seeking from the Secretary of State, when they wrongfully rejected you, that's public information. So that's one example.
If I could add one thing, we've been through this before in one other instance, and that is with respect to the Minnesota Supreme Court's quo warranto, original jurisdiction. So quo warranto means by what warrant, government, do you undertake this action? And in the end of fiscal biennium case, I represented 33 state legislators. Speaker Swigum, I think it's 27 Republicans and 6 Democrats. And we read the statute to say that original jurisdiction over the quo warranto is in the Minnesota Supreme Court. And in the federal court, when the phrase original jurisdiction is used, it always means exclusive jurisdiction. There's no question about that. That if the federal Congress says original jurisdiction in the U.S. Supreme Court, everyone knows that's exclusive jurisdiction. So from our part, in the quo warranto case back with Speaker Swigum, when the Supreme Court said, well, original jurisdiction but not exclusive, you start in the district court, and then we brought the action to district court found it had jurisdiction, and we found out something new. So there's something, oh, and then I should mention that was the case where the Minnesota Voters Alliance, following up on that jurisdictional decision, successfully sued the Secretary of State Ritchie for going with the online voter registration without having a statute supporting it, so that the writ of quo warranto was issued in that case. And so here, I can't say that I thought of it in advance, because everyone thought 204B petitions were filed in the Minnesota Supreme Court because the statute says original jurisdiction. It's a surprise to me, but it's a good surprise, as I mentioned. The Minnesota Supreme Court has said you can bring now 204B petitions in district court. So the petition in district court isn't a lawsuit, isn't a petition for writ of quo warranto, mandamus, or some sort of injunction. It's a 204B errors and omissions petition to the district court. And prior to September 28th, if I had done that, everyone would have said, you're crazy. But now the Minnesota Supreme Court has said, no, there's a private cause of action under 204B to bring action in district court against the Secretary of State. I mean, that's huge if you're concerned about election law integrity, because of course the last stop, if necessary, for election law integrity is the courts, because the Secretary of State isn't doing his or her job.